Okay, good evening, everybody. My name is Michelle. I'm going to be your anchor for today. So welcome to the JIIPCC Mentorship Program. Before we begin, I'd like to make some quick announcements. Firstly, we have JIIPCC has 30 minutes private mentorship with mentors available. Your favorite JIIPCC mentor. If you're interested in having 30 minutes with them, you can contact Mrs. Juliana for that information, speak to them, ask questions, any questions you have, maybe you want to pick their brain, anything like that. Secondly, I want to encourage every one of us to put our videos on, especially the mentees, so that we can get to know each other, see our faces, to get the gist. And then just a quick announcement that we are streaming live. So on our social media platforms, if you want to share the link with people, Facebook, I think YouTube, I think firstly Facebook. And fourthly, kindly, if you have not, edit your name in the name section of your Zoom profile, so that we can, for attendance purposes, we can get to know each other. And yes, registration for the second quarter of the mentorship session is ongoing right now. So if you want to go through it again, or you know someone that you want to tell about the second quarter, or you want to announce it on your status, however, just to advertise. Before we go into our presentations for today, I'll quickly speak about our two mentors. Firstly, we have Mr. Abiodun Sunaike. That's not the pronunciation, I apologize. Mr. Abiodun Esquire is a legal practitioner and a sports administrator. He holds an LLB degree from the prestigious University of Abuja with second-class upper division and was taught the Nigerian bar after bagging his BL from the Nigerian Law School Lagos campus. Mr. Abiodun started his law practice at the head office of the prominent Afebawalola and Co. in Ibadan. Thereafter, he worked with the law firm of Musibao Adetumbi, SAN and Co. before he moved to Osogbo, where he joined the office of Olatoye Aminu and Co. Having learned from the best in his profession, he wanted to add modernity to professionalism in order to provide proper framework for the emerging situations in Nigeria. So he joined others who shared his developmental mindset to form Lithos Legal Consult. Mr. Abiodun, a specialist in sports law, consults for various football associations, professional league teams, grassroots soccer teams, and football academies, coaches, and managers. He also serves on the board of a sports management company in Nigeria, Safe Play Sports Development and Media Entertainment Limited. He was a member of the electoral committee of the Osun State Football Association in the 2019 election. He's currently a member of the Osun State Football Association Committee on Legal Matters. He's also the International Legal Advisor for Kano International Football Academy, chaired by former African Footballer of the Year, Nwako Kanu. Mr. Abiodun is also a prolific litigation counsel with specialty in enforcement of fundamental human rights. He has gotten several judgments in his favor, prominent and recent, among whom is the celebrated case of Halima Adetola versus the Inspector General of Police and others. Secondly, we have Mr. Kachi Okezie. Mr. Kachi Okezie Esquire is a barrister and solicitor of the Supreme Court of Nigeria. He is an entrepreneur, he's a trainer, and he's a management consultant. He's also the founder of the Institute of Leadership Development and publisher Small Biz Nigeria magazine. Thank you so much for being here with us, sirs. So now we're going to have our presentation. We have 4 groups, group 1 to 4. Please, if you're a representative of group 1, 2, 3, 4, kindly indicate, unmute yourself and just announce that you're here. You have 8 minutes. Each group has 8 minutes. So we'll take group 1. Is your representative here? Group 1.
Yes, I'll be representing group 1.
Thank you. Please go ahead.
Okay. Okay. So my name is Oluwafemi Ojeshu. I'm representing Group 1, and our topic for today is the protection of inventions and brands in sports. So quickly. So can you see my screen?
Yes, you can see your screen. Thank
All right. Okay, so quickly moving on. The first question that crops up whenever we are discussing matters relating to intellectual property is, what is intellectual property? And I know this is a point we've more or less explained over and over again in this internship program, but just to refresh our minds, when we talk of IP, we talk basically about the creation of the human mind. Now, in the context of sports, when we talk of IP, we talk about all the underlying rights and features that make the organization of sporting events possible. These includes equipment, accessories, broadcast rights, the likes. So basically, protection of IP in sports, it's how I put it. It is an intertwined process, but for the sake of for the sake of classification, we will talk about protection of IP in sports in the context of protection of inventions and protection of brands. Now, a lot of these rights cut across each other, but we've attempted to streamline them for the sake of this presentation. So IP protection. So IP protection or rather protection of inventions in sports through IP is usually done through patents, industrial design, or in this case, patent design, patents, and copyright. So what is an invention? An invention is more or less an improvement on an existing existing product or an entirely new or novel products. So inventions in sports often have the effect of providing marginal gains to athletes, to teams, to officials. Basically, they more or less improve the experience, they improve the preparation for athletes. So in terms of these inventions, the first level of protection we'll be looking at is patents. Patents, as we know, is an exclusive right to an invention granted to an inventor for a limited period for them to exclusively exploit their invention. In sports, we've had a lot of inventions coming in sports. For those of us that follow soccer, we've seen the goal line technology introduced in the English Premier League. We have the video assistant referees, and we have the vanishing sprays. So these are all inventions that have been used and applied to sports. So in the case of the video assistant referees, there is a case, or there was a case between Galan and MediaPro. So basically, Galan is a Spanish businessman. He holds the rights to VAR, or video assistant referee, in Spain, and this uses the Hawkeye technology and all. So basically, MediaPro attempted to patent the VAR technology in Spain, and Galan more or less challenged them, and judgment was given in his favor, barring MediaPro from deploying the VAR technology in Spain. In the case of Aleman and FIFA, the Aleman is an inventor. He more or less invented the vanishing spray that is used by referees to more or less control the game, to delineate lines and all. So according to football rules, you can't have extra lines on the pitch. So the vanishing spray more or less got around this rule by being by being temporary, so to speak. So after you spray it, after a while, it dissolves into water. So it was first used at the 2018 World Cup in Russia. Aleman pitched the idea to FIFA, gave them samples to use. But then FIFA now turned around and more or less encouraged other inventors to, will I say, exploit the patent, the technology, on the basis that Aleman's patent for the vanishing spray, which he obtained in Brazil, had expired. So basically, FIFA did not want to pay anything for using the vanishing spray technology. So currently, they are well, I won't say currently they are in court, and a decision has not been given in respect of that. With respect to designs or industrial designs, there are a lot of designs that more or less, let's say, improve how a piece of equipment or an accessory is used in sports. So I'll be giving the example of the British cycling team. They visited prior to 2003. They were very, very poor as a team. So they hired a new coach who redesigned their bicycle seats, redesigned their shirts to, how do I put it now, not to more or less be thin sweat and these inventions in quotes led to marginal gains that made the British team win the Tour de France, win the Olympics and all in cycling. But also the waffle design that gave birth to Nike was also as a means of improving the design of the product. So Nike founders, Bowerman and Phil Knight, we are looking for an all-purpose shoes that will be usable in all terrain. And they came up with the waffle design. That's the spikes that we have today through experimenting and it's more or less changed athletics as we know it. And then there is also the case of the Nike Converse issue, whereby the Chuck Taylors, which we can see in this image, they are a brand of shoes which basketballers mostly use, and they had people from China counterfeiting the shoes, and Nike sued, and the court gave a ruling that those counterfeited shoes could not be imported into the USA. Then copyrights as regards to the protection of invention in sports. The entire sporting process, the entire, let's say, the Olympics, the FIFA World Cup, the EPL, it is a product. It is a product. It is a creation of the human mind, so to speak. And the EPL, FIFA, Olympics, they hold the rights to the broadcast of these products, so-called. So in the case of the EPL, there is this site, ISGO, that people regularly streamed English Premier League matches from. It is a bootleg site. It is an illegal site. And recently, earlier this month, the EPL applied to the US courts for a DMCA order that would more or less review the persons behind this sites and so that they can go after them. And shortly after that application, ISGO put out a statement that, oh, they respected EPL rights in the broadcast of matches, and that they would no longer be pirating their products. So that was how the EPL, using copyright in quotes, protected their rights as the sole broadcasters of the EPL, or rather the sole right owners, the sole persons with the right to license the broadcast of EPL matches. So moving on, we are moving on to the protection of brands in sports. So basically, what is a brand? And a brand is more or less let's say, identifying mark in quotes, and it's like an idea of your product, of your company in the mind of your consumers. And branding is important in sports because, I mean, it is your brand that gets you fans, it is your brand that gets you customers, it is your brand, or it is the strength of your brand that get you viewers. I mean, we know the effects Cristiano Ronaldo's move from Madrid to Juventus had on the sale of shirts. We know what his move from Juventus to Man U had on the share price of Man United stocks in the stock market. So also the move of Neymar Jr. from Barca to PSG. It is usually said, although not factually right, that the sales of Neymar shirts more or less made up for his transfer fees. So that is how strong brands are. So protecting brands in sports is usually through a combination of trademarks in the cases of entities or companies, and then personality rights, also known as image rights, or publicity rights in the case of individuals, sportsmen, athletes, and all. So trademark basically, trademark basically is a sign used to distinguish one's goods or services from that of a competitor. And one of the most recognizable trademark in sports is the Nike swoosh mark, the Just Do It mark. So Nike protects its brand through litigation. Well, I mean, by trademarking it and litigating against people that look to dilute them. And Nike have had collaborations with a lot of athletes, such as Michael Jordan for the Air Jordan series, that more or less boosts their profile. And they actively, just like as regards with design patents, they actively protect their brand against dilution. Another one that readily comes to mind is the FIFA World Cup. So the FIFA World Cup have this, let's say, they have this product or this package whereby they have official partners for a lot of things. They have Coke as their official soft drink partner. They have Adidas as their official kits manufacturer, and so they have partners for literally everything. And the the benefit of that this thing partnership for these partners is that their brands are being seen worldwide. They are on a worldwide platform. It's like having a Super Bowl ad. Like the whole of the United States are watching the Super Bowl, so everyone is seeing your ad. That's the way the FIFA World Cup merchandising works. So you have the right to use FIFA's brand on your products. You have the right to produce FIFA branded merchandise. However, there is an interesting thing I found out whilst doing this research, and that is called ambush marketing. So basically, Nike has been doing ambush marketing as regards the FIFA World Cup since 1998. Nike is not an official partner of FIFA for the World Cup. Adidas is, but a lot of times you see that Nike's brand leading up to the World Cup is even more popular than that of Adidas, which is the official brand partner. So I think either the 2014 or the 2018 World Cup, Nike put out this Write the Future ad that was on YouTube and Nike's ad, though it did not reference the World Cup, was released in the lead up to the World Cup, and it had more views on YouTube than the video of the official partner of FIFA. And it is something Nike has been doing since 1998. But because Nike does not directly reference the FIFA World Cup or use any of FIFA branded merchandise or FIFA branded logo, it has more or less been circumventing those restrictions and has been riding on the popularity of the World Cup, so to speak, to project its brand. Then we have personality rights. Personality rights, basically, also known as image rights, includes the use of the name, likeness, and identifying features of an athlete to promote a product or service. And this was well defined in the case of practice sports management and Wayne Rooney. Like I mentioned earlier, we have players like Cristiano Ronaldo, Lionel Messi, Zlatan Ibrahimovic, who have become household names in the sport. And in Formula One, we have people like Lewis Hamilton. Basketball, we have Kobe Bryant, Michael Jordan, LeBron James, and the likes. So these guys have more or less leveraged on their personality, on their brands to ink deals, to ink products. And so how are these their rights protected? Well, it's more or less similar to trademark. Beckham is more or less regarded as the first superstar football icon. So basically, these guys protect their rights under image rights, and they have these usually when a player signs a contract with a football club, they also negotiate the use of their image rights separately. And one of the cases where the image rights of an athlete has been exploited by another is in the case of Kwiando Sports and Michael Jordan. So Kwiando Sports, but Kwiando is like a Chinese transliteration of Jordan. So basically, since they were registered, they've been using Jordan's name, Jordan's number 23 is Jumpman logo. This is the Jumpman logo. So basically, they registered everything as assets in China. So given Jordan's partnership with Nike, and also based on Chinese laws, Nike could not sue. So Jordan was the one that could sue. And Kiadon argued that, oh, anyone could be Jordan. I mean, it could be, and that Michael Jordan was not the only Jordan in a sport. But evidence of them also trademarking is Jumpman logo, his famous number 23 shirts, doing counterfeit copies of his Air Jordans were also put before the court. And well, the court restrained Kiadon Sports from parading itself as a right holder to Michael Jordan's personality rights and all. But then the court failed to punish them for the previous usage of the marks. Basically, the court did not ask them to give an account. Sales of previous Michael proceeds from sales of previous Michael Jordan branded products. The court did not order them to pay those proceeds as against the, well, I say, well, I won't say the normal cost of, but basically the court only restrained them from using it. It did not award damages against them. And then there's also the case of Cristiano Ronaldo, who sold 50% of his image rights to Peter Lim to more or less exploit in Asia to make him a brand, to make his brand more popular in Asia. So basically, these guys assign or license their rights to others to exploit for them, and in such a, and for those that are not licensed, they go against them in court to protect their brands, to protect their rights in court. And so summarily, inventions and brands in sports are protected through an intertwined combination of patents, designs, copyrights, trademarks, personality rights, licensing, merchandising, basically. And it is the culmination of all these IP rights that makes sports what it is, that makes the let's say, organization of sporting events possible, because because organizers know that their product and the associated rights are protected, and where someone infringes, they can easily move against the person to get damages for infringements. So thank you for listening. That is our presentation.
Thank you so much, Oluwafemi, for your very, very enlightening presentation. Before we move on to group 2, please, we're encouraged very quickly to have our videos on. Is the representative for group 2 here with us? Group 2. Group 2. Anybody? Okay, how about group 3? Okay, please go ahead. Please know that you have 8 minutes. 8 minutes. Yes.
Hello?
We can't hear you clearly, but we can hear you, but it's not so clear. Hello?
Hello, please, can you hear me now?
Yes, we can hear you now. better.
Okay. Please, if we come in here, just in the description. How much?
Are you with us, Nifemi? I don't think he is. Okay.
Hello?
Yes, hello?
Please, can everybody hear me?
We can hear you, yes.
Shit. So I was saying that okay. So I was saying that our topic is on broadcast in sports. So without overwhelming us with the issue of IP and IP rights, I'll just say that we all know that IP rights stem from a set of intellectual property, while IP itself simply refers to a category of property that includes intangible creations of the human intellect. So I don't need to go. Let me just skip that. Intellectual property, we know what it means, and then let me just go straight to our point, to our topic for today. So broadcast rights. Okay, we have the English. It means or any and all rights to negotiate, broadcast, disseminate by radio, television, motion picture, satellite, videotape, and internet or worldwide web telecast, production, exhibition, or other sound of visual expectation of the championship. Okay, basically, broadcast rights, let me just give you an illustration. Broadcast rights is when, let me say, Mr. A or a party is organizing an event, a sporting event, not basically just sport event. Let me just say an event generally. So, okay, you, or for example, concert. So, okay, that your event, it is not available to the public. So broadcast is one of the ways you can actually export an event apart from, okay, let's say Mr. A is organizing an event, but the event is only open to people that buy tickets to that event. So, okay, how does people outside the tickets watch it? That's the way you can actually still commercialize that event by, it's basically issuing rights to another party. Party A is the one organizing the event. Okay, party A is now licensing another party. Okay, you have the right, you are the only one that have the right to broadcast my event to the world. So normally, ideally, the event is open to only those that buy the tickets. But now, for other people outside the event to watch it, you give that right. You listen that right to another party. That broadcasting right to broadcast to everybody outside. That's actually broadcasting right. The right given to another to broadcast the event to the world at large. And that is simply the meaning of broadcasting rights. So, okay. So it is the term for the media rights to an intellectual property object sold to a particular broadcasting company. I think that's actually what I just said. So it is the term for the media rights to an intellectual property object sold to a particular broadcasting company. So basically, if a company wants the media rights to a sports organization or a competitive video game, they contact the distributing organization. That is like the likes of when it comes to sport, we're talking of the likes of Supersport, Sky Sport, and Co. So just like I said earlier, the broadcast rights sales help finance media sporting events. Okay, I don't want to go directly into broadcasting sports here, because that's another topic. Which says, okay, now we have. Okay, let me just go to broadcast. Broadcast rights includes, when I'm talking about broadcasting rights, it includes the. Okay, now in broadcasting sports, let me just broadcasting sports. In sports, copyright and related rights, particularly those relating to broadcasting, underpin the relationship between sports, television, and other media. Television and media organizations have been known to enter bidding wars with the winner, enjoying the privilege of an exclusive or non-exclusive license to broadcast sporting events. Okay, now let me try and bring it from the background. Now, I've explained in a larger way the broadcasting rights, basically what it means. Now, when we come to sport, broadcasting rights, or let me say broadcast rights, has actually been a major source of revenue for sporting events. Now, this is where it stems from. Sport, basically, the act of sport, let me say soccer sport or football, it has been argued that on its own cannot be protected by any form of IP rights. You running around playing football has been argued that it's not a creative, such a creative art that could have been said, okay, it can be protected. So I think that's actually the basic background where we now, okay, let's go for broadcasting right. So it's like a kind of rescue way for us to, or for sportsmen to exploit the activities, because basically or ideally sport activity cannot be protected by, or cannot be exploited, cannot be protected or exploited with the use of any IP right, because it has been they are not creative or invention that can be protected. So now that is where broadcasting rights comes in. So okay, yes, you cannot protect our sporting activities. There's no way we can protect it. Okay, so now this is what to do. If you want to watch us live, it's either you come and buy our ticket and watch it live when we are doing it, or in another way, okay, if you still want to watch it, we cannot just let everybody just watching it. We are not making money. So that is where that's why we have the television and media organizations like Sky Sports, Super Sports, and co. So now, what sports organizations do now is that's their sport activities. They will now give you the right to broadcast it. Yes, the right to broadcast that sport activities will now be given to specific media organization. Okay, now this is the organization that will be broadcasting this event to the world. You are the only one. So now they will like so now what they broadcast the event, the media organization that they give the rights will not be the one to now either it is exclusive or not exclusive. So in case of exclusive license, it is only to that organization. Where it is not exclusive license, then they can give it to that media organization can now sub-license to others. I don't know if you know, but that is why. And I think it's not World War, the last World War, you cannot, yeah, for example, now, if you are watching a live football on YouTube, if you notice on YouTube, you cannot record or screenshot, you cannot download. You can only watch it at that time. That is exclusive, that is broadcast rights. So that broadcast right is only given to that organization to broadcast it. So let me go on. So it's said that the value of this right runs into millions in dollars. For top Peter sports and media organizations, the sale of broadcasting and media licensing represent their biggest of revenue, generating the funds needed to finance the sporting events, pay wages of elite athletes and players, refurbish stadiums, contribute to the development of sports at grassroots level, and more. I think I've said this earlier. Broadcasting rights has unarguably been a major, or let me say, a greater source of revenue for sports events or for sporting organizations. That is why during COVID-19, during COVID-19, a lot of sports organizations have a lot of issues because the broadcast rights, which is what the major source of revenue, they were unable to utilize it. A lot of, okay, for example, now Premier League was not going on. The match that they are playing, which they get the broadcast rights from, they're not expecting it. There were even issues of breach of contract on what would be the ex-COVID-19 issues, or let's say post-COVID-19 issue between the sports media organization and the sport organization, how to relate the broadcast that have been licensed and the the issue of sports activity not going on. So during COVID-19, a lot of sport organizations really have a lot of issues because broadcast rights is actually related to the activities of the sports going on. So the funds are not coming, and then there is issue. The paying of players, the renovation of stadiums, and a lot of things is not going on because sports activity or broadcasting rights is not being active. So the world of Premier football is the classic example. Exactly. I've been talking about football before. I think there's been a classic example we can use when we are talking about broadcast rights. So for example, here we have the English Premier League, which has always been ahead of other leagues in terms of earnings, thanks to its lucrative TV rights in comparison with other leagues. Operates a centralized distribution. Okay, before I go far, okay, okay, I think I've said this. Exclusive rights. I've spoken about exclusive rights. Okay, now you have image rights in relation to broadcasting rights. In the world of football and sports in general, image rights are the right intrinsically belonging to a player to control, sell, license, and in doing so monetize his or her likeness. That is his or her image, name, nickname, voice, signature, and all other active characteristics unique to the player. So I think that's even one of our questions that we are assigned to our mentors on the issue of the relationship between image rights and broadcasting rights. What is the thin line? Is there a way whereby in the issue in the process of exploiting broadcasting rights, you hey good. Are you still on? Okay, okay. So in the issue of exploiting broadcasting rights, while exploiting broadcasting rights, we also is there a thin line, or let me say where is the thin line when exploiting broadcasting rights you infringe on the image rights? Okay, yeah, they said that under the Nigerian Premier League football law, under the Nigerian Premier Football League rules, a player's image right obligation are expressly incorporated in Form 7 of the rules, specifically in clause 4.3 through 4.7. Clause 4.3 of the contract is the assignment clause that recognizes the club's right to exploit the player's image right. By clause 4.4, the player agrees not to undertake any promotional activities on the club's behalf, nor assign his image rights to any other person. The player is further obliged under Article 4.5 of the contract to undertake promotional activities. Okay, in short, what you're saying here is that under NPFL, for example, the club and there is an agreement between the club and player and us on relating to the player image right. They can't just put the player image on an advertisement. No, the club cannot just use anyhow. Even and then I think the argument is that for MPFL, so there is also an agreement between MPFL, the football club and the player, which says that only I think just 4 players. Every club is to give just 4 players to MPFL to explore their image right, probably but with their sponsors when we're talking about endorsement and sponsorship, then for the sponsors to use in the ads. So just I think every club has only just to give 4 players. I'm pretty sure of Premier League. Every club is to give the Premier League 4 players to explain their image right in relationship with their sponsors and endorsements and co. So now, next slide. Yeah, it says that next slide. The club is obliged to ensure that the player's photograph or image does not imply an endorsement by the player of the product or service being promoted. This was the thrust of the dispute between Mohamed Salah and Egypt Football Federation, where the players' representatives alleged that their client's image was subjected to greater use. This appeared out of his teammate and gave the impression that the player endorsed the use of Egypt here. That is it. What I'm talking about, that's what I was saying before that. Football Federation, exactly, and the player and the club. The Football Federation cannot just take a player's name. Yes, the club has 4 players that they will give. Those players must be used equally, not exploiting one at the other, at the expense of other. No. If we are going to do that, there will be an extra agreement between the federation and the player. And I think the club has that right to exploit the players. And primarily on the Premier League, the club has the right to exploit the player image right. But there is already a kind of sharing formula between the player and the club when it comes to exploitation of the image rights. But I don't have the. Okay, now we are talking about broadcast rights. Next slide. Broadcasters' rights include safeguard costly investment. Okay, so now we say that under the International Convention for the Protection of Performers, producers of phonograms are broadcasting organizations. Broadcasters have exclusive rights for 20 years to authorize rebroadcasting, fixation, reproduction, and communication to the public of their broadcast. Yeah. Oh God. Okay. So we have case study. Let me just give us our case study. The case study we have the issue of the recent case of Real Madrid with La Liga challenging the Spanish soccer bodies authority to commercialize the league's rights by a league. To commercialize the league's broadcast rights is instructive for understanding the need for centralized control of broadcasting rights by a league. The Madrid court dismissed the reigning Spanish Champions League claim, ruling in favor of La Liga's centralized rights management and its responsibility to increase the value of the competition domestically and abroad. Real Madrid requested that the court make it mandatory for La Liga to provide and prepare thorough financial accounts for 2018-2019 session, including details on the sale of the league's broadcast rights. The court's ruling dismissed all those claims. It said that La Liga has an unequivocal right role in the commercial management of audio, visual rights, and in the exercise of its obligation, it is required to guarantee optimal management and investment. Okay, I think basically, before I conclude, let me just say that I skipped that they are basically forced to understand that case studies. There are two types of broadcasting rights. It can be individual and it can be collective. In US, the practice collective right. That is where all clubs submit their broadcast right to the federation, and then the federation then agree on how to share it. Whereas in Premier League, it is individual. Every club has their rights to exploit their broadcasting right by using your club. Once you have a stadium, you are the one that we are starting to a major organization. Now, so I think that's will help us understand what is happening there. In Spanish, they have a centralized one. That's also collective right. So every club assigned their broadcasting right to the La Liga to exploit it. And that will help us to understand that case study. And then we have the one on DSTV here. Okay, now for example, now we have DSTV as a case study. DSTV is a sub-Saharan direct broadcasting satellite service from South Africa and the largest operator in Africa. DSTV boarded, okay, now, DSTV boasted 10.26 million subscribers as of 2019 to statistica.com, and it is also the broadcast partner of the Nigerian Premier Football League. This deal has ensured that the popular channel's passport of DSTV will remain the official broadcaster of the NPFL until 2025. This threat also extends across the entire broadcast territory of Sub-Saharan Africa, including South Africa, in all languages and through all distribution platforms, including television, internet, and mobile. Then our conclusion: the influence of IP in every sector is inexhaustible. According to Kamel Idris, former director of JIIPCC, said that IP is a power tool for economic development that is not yet being used to optimal effect in all countries. Particularly in the developing world, it offers the possibility of growth and economic development in a way that is not a zero-sum game, where some win, others will lose. I think this is just sum up the presentation. Broadcasting rights in the influence of broadcast rights to sports event or sports industry cannot be overemphasized. It has actually contributed to a large extent to the existence and the continuous existence of our organization. Thank you for listening. Thank you.
Thank you, Nifemi, and thank you.
I can't hear anything.
Can we have group four representatives if you're here, please?
Yes, I'm here. Good evening, everyone. Can you hear me?
Yes, we can hear you.
Okay, so I'll wait for, please, Sekinat, if you're available, please help me share the slides. Sorry. Okay.
Can you see my screen? Can you see the screen?
Yes, I can. Thank you.
Can?
Yes, yes, I can, Sekinat. Thank you so much.
Okay.
Okay, good evening, everyone. So I am representing Group 4, and we're talking about arbitration in sports. And I know we probably were expecting to see a guy, but then this year we are breaking the bias, so I am going to be doing this today. So arbitration in sports, basically, we all know what arbitration is. Checking out, yes, thank you. I can't see the slides. Okay, we all know what arbitration is, so I wouldn't really go into explaining what arbitration is, but I'll just go straight to what we want to discuss today. So conflicts are inevitable in whatever daily activities we engage in, most especially where you see sports. and you watch football and you see how rough it can get sometimes, and there are so many things that can go wrong. But the point we are trying to drive with our presentation is the fact that arbitration is the most sought after means of dispute resolution in the world of sports, and that is because of the speed that comes with it. You know, sports is an ongoing event. Maybe when they are playing the Olympic Games, it's ongoing. So something can really go wrong. Something could happen, yes, but then you don't expect everybody who's playing to just pause till a decision is reached before any other thing can be done. So arbitration serves as a faster process, a faster procedure, and then awards can be given, decisions can be made immediately, and then we could go on and proceed with the game that is being played. Second, please, the next slide. Okay, so we're going to procedure for sports arbitration. First, in most charters or most bodies that regulate sports, most of them have the arbitration clause included in their charters. It's specifically provided for in so many charters that provide for sports generally worldwide. FIFA, UEFA, NAF in the case of NFF, in the case of Nigeria, these statutes, these bodies always provide for arbitration to be the recourse in the case of any dispute that arises, and that's because of what I've explained earlier, the speed that comes with it. So the procedure for sports arbitration is that it's included in these charters, and then in agreement between parties or between clubs or between players, arbitration is always, the clause is always inserted. Appointment, setting up and commencement of arbitration in accordance with the arbitration rules that are set in place or that govern that particular sports or field of sports. Then case management. Case management is like an early hearing for the tribunal to identify, the crux of the matter, identify what really is the issue before going to the main hearing, and then arbitration award is granted. Second, please, next slide. So examples of arbitrable sports disputes, we have appeals against disciplinary sanctions. We can have appeals against disciplinary sanctions. An example is what we have happening currently in the Football Union of Russia, where they have appealed to CAS. CAS is the Court of Arbitration of Sports. It's globally recognized as the sort of like the Supreme Court of Sports. So currently, FIFA and UEFA banned the Football Union of Russia from playing in any of their leagues or any of their matches. So currently we have, I think on the 28th of February, just last month, we have a pending appeal to the tribunal, to the CAS appeal, tribunal. We have a pending appeal before them currently, where the Football Union of Russia, they are appealing against these sanctions that were leveled against them, by FIFA and then UEFA. Okay, second one is appeals against athlete selection decisions. When clubs are selecting their athletes, if issues arise from these selection processes, I think there are a window period for selection for most sports. And so within this window period, if any issue arises from these, I think a case study was in the case of Man City. Yes, in the case of Man City, where they exceeded the threshold that was set for them to be able to purchase their players or get players. They exceeded that threshold, and I think some sanctions were leveled against them. So this is one of the situations where you can see an appeal can arise and go to CAS. That is the go to CAS for resolve. The third one is the commercial and contractual issues. Commercial and contractual issues between coaches and even the players as well are all arbitrable cases. Discrimination claims. We all would remember the case of Balotelli, a player, I think in Inter Milan, yes, where he has fans calling him monkeys and all of that stuff. These are issues that can be arbitrated upon if this player decides to take it up. So funding appeals is the next one. It's also arbitrable. Relegation and promotion issues are also arbitrable. It matters. Then player eligibility as well. I think there was this season that Chelsea they were banned from for a two-window period ban from being able to get players, from being able to sign players, because I think they signed up and underage. So player eligibility, it could be an issue. So these are issues that all could be arbitrated upon within the sports world. Second at, okay, so arbitration of sports disputes in Nigeria. Okay, coming home to Nigeria, it is, we do not have, okay, the NFF statute provides that NFF shall provide necessary institutional body for resolving disputes. This means that we are supposed to, within our territory, within Nigeria, we're supposed to have a statutory body, an institution that resolves disputes. And this has been made provisions for in the NFF statutes. But now we find out that in the real sense of it, there is no such body, regulatory body, that is available in the Nigerian phase to handle disputes. So we have various articles that were outlined here with specific provisions. Article 73 of the NFF statute disapproves recourse to ordinary courts. It disapproved the recourse to ordinary courts. It's that article is saying, in essence, that before recourse can be made to ordinary courts for issues that are directly or indirectly related to sports, or that from issues that come up within the Nigerian sports sphere, it should first of all go through arbitral means before. Also, we have the absence of a National Court of Arbitration for sports, and this has led to recourse to ordinary courts. We have cases like Sam Jaja versus NFF case. We have another case where an arbitral award was given, and over a year, nothing really happened. Nothing happened. There was no enforcement of this arbitral award, and so these players had to now take up the case to the National Industrial Court. So these are cases that we have that I've seen in Nigeria. We do not have a regulatory body yet, a regulatory body or a sports court that sees to the arbitration of issues that arise from our sporting events. Sekinat, please, the next slide. Another issue that could arise also is the novelty of sport law in Nigeria. We should, okay, someone is chatting me on, hello, can you hear me? Okay.
Yes, we can hear you.
Oh, 1 minute left, so sorry. Okay, so, okay, oh, 1 minute left. Okay, okay, I'll just go straight to the CAS. That's the Court of Arbitration for Sports, because that's majorly where our discussion lies upon. So the CAS is the Court of Arbitration for Sports, and then it's recognized globally as sort of the Supreme Court of matters when it comes to sports-related issues. Just like I earlier on stated, the Football Union of Russia currently even has an appeal ongoing before them. So the Court of Arbitration for Sports is located in Switzerland, and that is where the seat of appeal is. It has three divisions. It has three divisions, sorry. The ordinary arbitration division, the anti-doping division, the appeal arbitration division. But what we see mostly is that most cases actually go to the appeal arbitration division, because most cases that come to them, they are coming from the decisions of regional bodies or decisions of already existing bodies like the UEFA that is in charge of Europe, then FIFA, or in the case of or CAF, they could have decisions that have already been reached by these bodies. Then the club or a player or anyone now wants to challenge this decision that has been reached. So where they take these matters to is the Court of Arbitration for Sports. Okay, so can I move forward? Sorry. Okay, global arbitration of sports disputes. The United States of America, they have no single federal legislation for regulating their sports. So, but they, however, have the American Arbitration Association, and it provides for athletes, individuals, and sports organizations with a wide range of dispute resolution services. That its acronym is the AAA, National Commercial Sports Panel. In the United Kingdom, under the English law, we have the Arbitration Act, and then it authorizes that disputes can be resolved through arbitration, even in their world of sports. In China, we have the People's Republic of China on physical culture and sports, and it established arbitration institutions for resolving their sports matters. In the United Arab Emirates, a UAE chapter of the Court of Arbitration for Sports is currently being set up in that country, and it's currently ongoing, not yet fully completed. In India, we have a government-appointed observer, and this is a prerequisite for registration of any sports society in India. Okay, I'll just jump to conclusion. In conclusion, arbitration should be extensively and effectively explored in resolving sports disputes, both statutorily and in practice. This will in return promote ease in the affairs of the sports industry in Nigeria, Africa, and globally. So in conclusion, we are saying that in our region, that is Africa, the African region should come up with a body or their own court. This would really promote, grow our teams, the regional teams. Even in Nigeria, it can grow the Nigerian teams and make sure that these bodies are there to always settle disputes. In my group, while we were having our discussions, we made a reference to, we made an observation, and then we were of the opinion that we could actually in Nigeria have things like when the military has a court martial, we could include, have something like that happening in the sports sphere of the Nigerian Athletes Committee, so that when some things go wrong or some things happen and some disputes needs to be resolved, this committee can come up, sit, and then even before recourse is made to any other body, they can sit and their awards should be enforced and it should be recognized. Thank you. I don't know. Sorry, I took most of your time. Sorry so much. Thank you so much.
Thank you, Chisom, and thank you, Group 4. So quickly, we'll move to Group 2. I hope they are here. Group 2 representative. Okay, I don't think. Okay, since Group 2 is not here, we'll quickly have comments from our mentors, Mr. Kachi and Mr. Abiodun. Maybe we can have you first, Mr. Kachi. Okay. Here.
Yeah, thank you so much. Thank you. Can you hear me?
Yes, sir, we can hear you.
Right, excellent. I actually would have thought that you would take the feedback after each presentation. I think that way it will probably be perhaps enriched, because it'll be more spontaneous, it'll be more closer to the event, but that's okay. Overall, can I just say that I'm very impressed with the whole concept and with what you have done. A lot of work. I did not expect this level of quality of presentations. I did go through them. I really did not think it would be this professional. I am very encouraged. We've been doing one or two things at the Bar Association. It's all confused. Nobody's serious about them. And so I'm very, very impressed with this. And I'm going to speak to Juliana more about this. And whoever put this together, kudos to you. Let me start from the last speaker, a very almost fiery gender campaigner that we just had. I think I tend to have a bias for dispute resolution in sports, so that's probably explains my sort of interest in that particular presentation. Now, I wasn't clear. Overall, a very good, very competent, well-researched presentation. I think that concerning Nigeria, I was involved. I have been involved with a few others. I think there were about 12 or 11 of us. There were 2 senior advocates there. The Abakoba was there, and a few other people in developing for Nigeria a sports industry policy, which was commissioned through the Nigeria Economic Summit Group. And we were set up by the Ministry for Sport. as a sort of technical committee to help develop that policy. We spent a lot of hours, we had a retreat, and we produced this work. And much to our complete disappointment, it's sitting somewhere now. I think it's been to FEC, the Federal Executive Council, and it's sitting to where, and it answers all the questions raised in the last presentation. It addresses everything that was said in there concerning having this dispute resolution mechanism. So it's not just that, that's just one component of this policy. I would say that anybody who has anything to do with the sports industry in Nigeria, please do what you can to encourage advocacy to make sure that this policy does not just die on shelves. Okay, so Nigeria now on paper does have that. You know, we've set it all up. It's just about passing it through FEC, but they're playing politics with it. Okay, now the speaker did not. I don't know if this was deliberate or not. Did not seem to say much about mediation. Mediation is actually growing very fast. Obviously, being more flexible than arbitration, which we all got involved in a few years ago. So mediation is something also that is growing very fast. And in the design of the policy, we incorporated mediation into it, the Nigerian policy. So for the last speaker, I think it was overall a very competent presentation, and I like the opening gambit with the, making it all relevant and current and contemporary, with the comment about gender. So good on you. Some of us are he for she's. Now, concerning, I think it was group 2. Group 2 had, I think, a lot of information, but I think very little time to present them. And I think the speaker sort of ran into difficulty and ended up having to read. That is a no-no. That is a no-no, it just shuts people off. But that did not stop me looking at the information. There's so much in that presentation that I would seriously recommend it to anyone. But perhaps if he was a bit more relaxed and tried some breathing techniques and things like that, it would be perhaps better, more professionally presented. But when it comes to the information it's there, I think it's extremely rich and speaks to quite a lot of issues that are relevant. So that was good as well. But I really, it would be unfair of me to say that the presentation itself was as expected. Now, I expected more sort of in control presentation that wasn't. Group 1, was that Oluwafemi?
Yes, sir, it was.
Yes. Well, Group 1, I'm sorry, I'd like to work for you. I'm so impressed. I was so impressed by the simplicity of the slides. The slides were friendly, attractive. The color balance, the graphics were easy to follow. And the passion and the knowledge and the enthusiasm of the speaker were extremely infectious. And I didn't want it to end. And I know he went over time. I know he went well over time, but I didn't want it to end. I didn't mind. So I thought that was a really, really good one. The only thing I would have liked to mention by way of something to address in terms of going forward would be try to get the message first before the stories, okay? When you begin to talk about or present, I always like to present cases as stories, real life stories. So if I'm talking about a case, I don't just present it as a legal case or whatever. I like to tell the story. And so he was doing quite a lot of that, but I think he was getting carried away with it as well. That's for us to do, not you, okay? So overall, 3 very good presentations, but number 1 was just incredible. Thank you.
Thank you, sir.
I don't know if we'll have another chance for another comment. I don't know how that works. I'm not quite sure how it works at the moment, but those are my thoughts at this stage.
Thank you, sir. Thank you, sir. Okay, we'll have Mr. Abiodun.
Thank you very much for having me. It's a privilege here. And thank you, Mr. Hachi. I think from one of the things he said, I also feel that if the comments could actually be coming immediately after each presentation, they could actually be continuous and all, so that one could actually attack as they are coming. But by and large, like he said, the presentations were actually wonderful. I had gone through them even before now, and I can tell you that I am very, very impressed. So I won't really dwell much on the theoretical aspect, because I am like a lawyer on the field. I mean, when it comes to sports law, you always see case study every day. So let me start with from one of the things I want to point out. Group one, he was talking about, while he was talking about the use of IP, and then he said that, so I wanted to point out that the marginal gain is not actually limited to athletes. He said to athletes. Actually, it's not limited to athletes. Actually, it is to every stakeholder, everybody that is involved in sport could actually make use of the gain that intellectual property can bring to sport. I think I need to clear that aspect. Now, overall, let me also talk about because of the way they come. So I'll just be picking those ones that came to my head. Now, on the issue of dispute resolution. Now, let me say that FIFA rules does not directly is addressed to me as a person, even if I am an athlete in Nigeria. Now, the FIFA rule was actually directed to its members, and the members are the different confederations under FIFA. Now, that means that even though there is a FIFA statute, it does not directly bind a team in Nigeria, but indirectly it should. Now, you might not really get where I am going until I break it down. Now, CAF is a confederation under FIFA, and NFF is a federation under CAF, meaning that it is the CAF rules that directly affect NFF. Now, NFF make rules for clubs and players under them. Now, when it comes to dispute resolution, FIFA statute clearly states that every federation must have a dispute resolution chamber. Unfortunately, we do not have one in Nigeria present. Now, generally, the expectation of FIFA is that when there is a matter at the dispute resolution chamber level and somebody is not satisfied, they could actually appeal to a higher confederation, and from there to Court of Arbitration for Sport. So in the first instance, it means that generally, if it is not an international matter, I mean between two people of different nationalities, matters at first instance shouldn't actually go to FIFA in the first place. It should actually be something that should be, let's say I am a player playing for Kano Pillars. The matter should actually be something that a dispute resolution chamber should be able to settle here in Nigeria, but unfortunately we do not have. Now, you cannot say, now if the law is clear that where there is a wrong, there should be a remedy. Now, if there is nothing, as it were, to protect my rights under the sports law in Nigeria, because there is no dispute resolution chamber, I can always resort to Section 6C of the Constitution that says that I have the right to approach the court. That's what actually makes people approach the court. Highest that FIFA can do is to say, okay, because these people, they did not go to NFF or whatever, we are going to ban them. But you cannot actually stop them, because it means that I will have to now go to an ordinary court to enforce my contractual rights. So I think that's where the issue is. And I know about what Mr. Kachi was talking about when he was talking about the policy and all that, because the program during the COVID that led to Federal Ministry of Sport and NESG bringing up that committee, I actually attended and these issues were raised. But you know, in Nigeria, we always want to, there are a lot of things that we might not necessarily need to be discussing here. Now, I think that on that side, I'm trying to look at some other things. Okay, now coming to the issue of image rights and broadcast rights. I think somebody raised the question. It was part of the question. Just talk about it now, leave it till later. Hello?
You can go ahead,
Yeah?
sir. Yes, you can go ahead,
Okay.
sir. Yes.
Okay. When it comes to image rights actually has to do with the personality of the person. For instance, Cristiano Ronaldo is playing football. He is actually the one who owns the image rights. Now, let me say that world over, when it comes to sports, there is actually no law that specifically states that, specifically mentions image rights, as it were. So recourse is always added to the intellectual property law in every jurisdiction, as it were. So normally it is where that is always, but generally, by and large, if my image is the one being talked about here, I am the one who owns the image right. But mostly when it comes to footballers, mostly what they do is that once I am signing for a football club, the club will normally take, in the contract, there will be a part where they will mention, they will, like I am, for the moment I am playing for the club, I am selling some part of my image rights to the club to be able to use, especially, and they can now there are rules. Unfortunately, I might not be able to be reading some of them because I have samples of them here that talk about the fact that, well, so far that you are playing with us, I think one of the presenters made mention of something that looked like it tacitly when he was talking about Mohamed Salah, or only that he was talking in relation to the Egyptian FA. Now, if I am playing for Chelsea, for instance, the agreement would normally, naturally say that Chelsea has sponsors. So I am allowing the club to use my image so if the club needs me to come and show myself, to come and bring myself to advertise for those persons, I must not say that this is my image right, it cannot be done, because definitely I have already signed and allowed them to make use of it. Only that I will not, the club cannot specifically make use of me more than they will normally make use of other players. They cannot say because I am the superstar in the team, I am the only one they are going to be using. So, but at least there must be fairness in the way they use it. And also, if the official sponsor of the club is Adidas, for the moment that I am a player of that club, I am not allowed to advertise for Nike. But once I am no longer a player of that club, I am relieved of that. My image rights belongs to me again. I think something about the image rights. Now, on broadcasting rights. Broadcasting rights is actually a right that inures in mostly when it comes to all these clubs and all that. It is generally owned by the club. The player himself cannot say, okay, I played a match, and then now, without the authorization of the club, take a video, even though I am the one in the video. I am now saying, okay, I'm just using the video in it. I think I am presently, my law firm, something practical. Now, my law firm is doing a project that most likely will definitely come out next month. So we've not actually, so I will just, now he was a former player in the English Premier League who is a Nigerian. Now we wanted to create something for him that would actually bring the commercial benefit to him. And we will need to make use of some of his videos while he was playing for that team. Now the problem is that it will bring out that video. We should expect that that team will come and say that you have infringed on my broadcasting right, even though the player himself is in the video. Some players who are also in that video would come and say, you have infringed on my image right. So we have to find a way to, if either we are going to take authorization from the club directly to use it, or we are going to find a way to adapt the image in such a way that it will only bring our player and it will not be totally suggestive of what they could actually bring. And now let me give an example of something that happened that got to court. You know, there's this wave of NFTs that's going on now. And then John Terry and Board Ape Yacht, they partnered to do John Terry's NFT stuff. Now they put John Terry's pictures, and then they carried all the trophies he won. The Premier League, the Champions League, and all that around him. And as soon as that thing came out, UEFA picked them up and said that they wanted to sue John Terry for making use of the UEFA Champions League trophy, which actually belonged to UEFA. Now, John Terry had to either make peace with UEFA or go and remove that thing and remove Champions League from it. You see the way the image rights would actually overlap. And also now, if you want to make use of a broadcasting right and you want to make use of your image right in a way, some of the things you have to look at is that, okay, you are allowed to take a video and do a creative work of art that makes the video very, very different. So that the person that took the video will not be able to say, this is my intellectual property. Now, if I am taking Mr. Kachi as I am now, this is, and we could say that JIIPCC owns the broadcast rights of this thing we are looking at. If I want to make use of my video, for instance, like this, yes, I am the one in this image. What I have to do is that I have to find a way to be creative about this particular video you are looking at, so that it will be different from what every one of us are seeing here. If I cannot do that, even though it is my image here, I have actually breached the broadcast right, so to say, of this. So now I think, I don't know if I am able to justice to your question, but if there's anything that I did not touch, or maybe if I have confused you the more.
Yeah. I don't know. Can I come in? Can I just come in on a couple of points you raised in there?
All right, sir.
Yeah.
All right, sir.
Yeah. Because I think we're relating to the question, which is to explore the relationship between image rights and broadcast rights. And one of the presenters, I'm not quite sure which one, mentioned something, because it's a very dynamic area. It's a very dynamic area. Abiodun, the example, the illustration you were given now, it's a common challenge, but it's also evolving good practice solutions to that challenge. For example, it's been an age-long thing in broadcasting that you use what is called image right releases. It's a simple one-sheet authorization. Anytime you appear on BBC, ITV, as I've done many times, you sign that. It's a release. It's like a kind of license for them to, in other words, you're giving up those, you're permitting them to have use of your image for that purpose, usually for it's a temporary excision, you know? So it's usually a simple one-page thing. Photographers use it a lot. You go to a wedding, you take pictures, and then you sign the release. Otherwise, your pictures can be used to advertise some restaurant or some wedding venue somewhere, and you can't claim. You know, so if you use the release, it's a very simple, it's been there for a long time, but it's getting better now in terms of its usage. Because what happens is, I know I'm speaking from UK experience usually, what tends to happen is that for commercial progress, there's the need to balance these two imperatives. You know, if you are too carried away with people asserting their individual rights, then the commercial activity will suffer overall. So they try to strike a balance between the two, and that is why usually, like in music and all that, even when you go ahead and use, they're not going to rush to court. They just let you know. And now they have software that accounts for the usage and prepares it, translates it to financial, in monetary terms. And then you can easily resolve that and people get paid. But because, the same person you are trying to assert your right against will turn out tomorrow to be the person you need to go to for rights as well. So it's a continuing balance. It's a very dynamic area, continuing balance between the exigencies, the competing demands for protecting the image rights, but also to be able to do business in a commercial environment. That's one. Secondly, in the specific example that one of the presenters gave, one important point to note about the relationship between these two is the contract and also the status in law. He or she mentioned that a player signs a contract and then discusses image rights or negotiates image rights separately. Yes, that's an important significance. That's the reason for that. In the UK, for example, in Europe generally, the tax you pay for your employment is governed by employment law and pay as you earn. So your contract and all the loadings about your earnings in your contract go to Her Majesty's Revenue and Customs. That's the tax office in the UK. What you earn through your image rights and all of that commercial and intellectual property rights are your rights, in personam and in rep. They're not part of your employment. They're separate from your employment. They're accounted for separately. That comes on, so you are responsible. Some have companies that they form for that purpose. Some use agencies for collections, and some do it as sole traders. It used to be pretty common in those days to do it as sole traders. But recently, I don't know if there was an issue with Hamilton in Formula One. Okay, when he wanted to lease a jet, and the issue was whether it was him leasing or the company leasing. They had all those issues, and then it ended up being resolved that he had to, because I think the company that was used to lease it, he no longer owned it. And so he said he had use of the jet as a beneficiary, but not as an owner. And the UK authorities were not impressed. with that. And they viewed it as, if you press that argument, we will think you're trying to defraud. That's a totally different issue and a very serious issue. And that's how that was. So these are the nuances, the legal nuances around these things. The ones in your contract that you sign as a footballer or as a sportsman who joins a club, that's an employment contract governed by the principles of employment law. The other one is a business that you're doing. And so the tax you pay there will be company income tax, SITA. It will be SITA in Nigeria, okay? What you pay in the other one will be your payee type of tax, which the company pays on your behalf and all of that. So that's a very important distinction to bear in mind when we discuss this. Thank you.
Okay, thank you.
Thank
So
you, sir.
I think that is it's correct. I think I forgot to mention the ones the image rights outside your contract of employment, and also equally very important because that's where a lot of athletes could actually really make a lot of money.
Yeah, sure.
Thank you so much, sir. So quickly, before I read the questions on the chat already, if you have any questions, kindly put it on the chat. So I'll just read it out for our mentors. Just type it out in the chat. Or you can unmute yourself and ask. Quickly here, I think Mr. Abiodun has already touched on this. What is the relationship between broadcasting rights and image rights in sports? And can image rights be infringed while exercising or exploiting broadcast rights? That's the first one. Secondly,
I've already answered that.
yes. And then secondly, plausible policies for arbitration in sports in Nigeria. I'm guessing maybe it's what are plausible policies for arbitration in sports in Nigeria? To our mentors.
Yeah, okay. I think I should have finished with that point because I did mention it at the beginning when I spoke about the work we did in developing the sports industry policy for Nigeria, which had a major component being the need to set up. We didn't just leave it at the need, we actually did set up a sports tribunal for Nigeria, which will encompass both arbitration and mediation. Now, those two have been considered to go together. Now, why is it important? I think my colleague had already really given a detailed rationale for having these dispute settlement bodies at every level. It's just astonishing that we are allowing this thing to carry on this long. We are losing out in many ways, you know. But one of the things I personally discovered while we were going through that process, first of all, I made the recommendation that we should follow the CAS model and adopt it. Mutatis mutandis, no doubt about it. But the CAS model, there was no need, in my view, and in my submission, to reinvent the wheel. Why do I say that? Brazil, Australia, Ireland, and which other country? We're all looking for this thing. They were shopping around for which model to follow. I have had dealings with CAS. It's clear to anyone who really looks closely at what's going on that there's no way that the CAS model will not remain the ultimate structure for dispute resolution in sports globally. It will be, it's here to stay. So we need to get with that. We need to, I think, bury any idea of innovating further in that area. The innovation we should be looking for will be how to make it work better for us, but not to say we'll create it. Because, and this is the argument, I was at the Football Lawyers Conference in 2019 in London. Law in Sport, they organize that every year. So at the conference in London, I met the head of CAS. And I met the head of UEFA, and all, it was all lawyers, including the FIFA guys, Real Madrid. Many of them were there. We sat down, I remember, one evening around the table and talked about this. At that time, I had not been invited to be part of the structure here. We were discussing it generally. And they impressed on me the importance of following what already exists, which other people are following or will inevitably follow. The reason is that you will get support, technical support, if you have any problems developing it. It will be easy for them to, whether it's by training, by mentoring, by helping you with policy, whatever it is, they will do that. It's easy if it's the system that they already have. Then, if you also need things like financial support at some point, it will be easier to factor that in. Where you're running a system that's totally different from what they have or what the world sees as the global standard, you're on your own, basically. And you don't want to be there. Kenya has done it. Shortly after doing it, they came back. Can you hear me? Hello? Can you?
Yes, we can hear you.
Right.
We can hear you now.
Okay. So that's that.
Sorry, you're muted, sir.
Now, what we're looking at is how to make it work. But the other point I wanted to mention, is that, hello, it's like it's cutting out. Can you hear me? Hello, can you hear me?
We can hear you.
Yeah.
Yeah, we can hear you.
Very quickly. Okay, very, very quickly. The other point I wanted to mention is that, for example, in CAS right now, they have been criticized somehow over time for not doing enough for Africa and helping Africa grow in that area. I was at another conference in Switzerland where that happened. They were roundly criticized. And before they left that conference, there was a kind of commitment that they're now going to do better, providing opportunities for sports lawyers to come for internships and things like that. I was there. We all said all those things, and improving and strengthening governance. So they're happy to do those kind of things now. But I found as well that in Germany, there's a law firm in Germany. One of the representatives was also at the 2019 conference of sports football lawyers. And she told me that they actually run an arbitration system as a private firm. And the federations are their clients. Private firm. This is not national court, institutional court. This is a private firm, a group of experts in football law, sports law, got together, set this up, and FIFA and others, buy services. The basketball federation, I think, either in the US, is trying to develop in Africa. They were the ones engaged to do that. So the question I put before this stage, which I also put before the committee, is why don't we do that? Why don't we do that? Okay, so this is now an alternative, it's an adjunct to what we have. Rather than continue to wait for the federal government and the politicians to be ready and to deliver to us the sports structure that would help with dispute resolution, can we look at the legal route to perhaps having maybe a non-profit setup that offers this as a service? Because if you remember, in mediation, people come to mediation voluntarily and agree to be bound and all of that, to alternative dispute resolution. That's the main principle, so that things will move quickly. If both of us agree that there's a settlement and we sign the settlement, we're basically done with that. That will help reduce some of the disputes that we have, instead of waiting for courts. We have a matter that's been in court. This is the 13th year. I've given up, basically. 13th year for a simple matter. And it's just no good. Thank you.
Thank you, sir. Mr. Abiodun, do you have anything else to?
Okay, I will say that some of the things I want to say is that it is not one of the things I have always seen is the fact that number one, there is a lack of political will. I mean, from the administrative body to actually do anything. It is not because the solutions are not there. Almost every time, at least I follow some sport lawyers, even on LinkedIn and social media, we are always talking, we are solutions that they could not naturally look at, but they just turn another eye. And another thing I know that I have actually, for instance, I will give an example of a state. I know of a state football team that has produced a lot of players for this country, but that same football team cannot actually stand on its own. And I know that it would have been a different thing if they had had a sport lawyer. I have a player from the team that brought what the team called a contract for that team. And I looked at what the player brought. I told him, go and sign. If you want to leave, nobody will hold you down. This thing is nonsense. It's just one paper. So the same team I applied to be their legal advisor, not even for a fee, so that they will see things differently. They decided to, they said at first it became a political, they started saying I am not from the state and all that. Now by the time they dragged it front and back, the governor said they should be taking their sports law matter to the Ministry of Justice. Now you can imagine that kind of thing. I looked at them and these people are not serious. And this same thing is always shouting. Now, presently, they are not playing in their own stadium. They have been banished to another place because the stadium, the situation of the stadium is not good. It's not because they don't know what to do. It's because they do not want to do it. That's one. Then secondly, I would say that also the international body, and I think that Mr. Kachi has talked about it, the international body are always only interested in Africa whenever there is a kind of trouble, a very big trouble, especially administrative wahala, that both of them are fighting, and then the international body will now remember that there is a rule that they are not following, and then they will come and say, we are going to ban you and all that. It shouldn't be that. And then lastly, I want to say that all these policies will actually come into play when we see sport as business and not as recreation. If we see sport as business and we take it as business, believe you me, all these policies will naturally come into play, and then people will know the reason why they need sport lawyers. Because one of the reasons lawyers are not really going into it. Now you are training yourself to be a sport lawyer. Who is going to actually engage you? Now, when I started into sport law, I can't even count the number of free I have done. Because if you are not doing free, number one, you have to make these people know that they need a sport lawyer. Now, it will be an issue of, we cannot pay. Okay, don't worry. Let me do it for you so that you will see. Now, by the time you do all those free, it is at that point that you make them see the reason why they need a sport lawyer. That's when you cannot be saying, okay, I want to be charged. So that's the problem. If everybody is seeing this thing as a business, believe you me, we won't have this. In fact, we would have actually gone past this level. So that's my own contribution, actually.
Thank you very much, Mr. Abiodun. So in the absence of any questions, you can still unmute yourself to ask a question, but in the absence of any questions, I'd like to say a very big thank you to Mr. Kachi and Mr. Abiodun for joining us today. Mrs. Julian.
Okay, thank you very much, Michelle. Thank you for an amazing anchoring. Thank you so much. And then I also want to say a big thank you to Mr. Kachi. Thank you so much for your time and your wealth of experience that you've come to share with us. Thank you, Abiodun. Abiodun was my classmate in university, and I just reached out to him, and he was so gracious to say yes. Thank you so much, Abiodun. Thank you for sharing the practical aspect of actually being a sports lawyer. Thank you so much. And then to all my lovely faces, I can see your faces, Sekinat, Ogene Fego, Onyeka Chuku, and Chisom. Thank you so much. Thank you everyone for staying through the whole program from the 1st to the 8 weeks. You did it. Well done, everyone. And so our closing ceremony will be next week, Friday. Please be prepared because I want to hear everybody's voice. You would have about 3 to 5 minutes to just talk about where you're coming from, how it has been so far, and your plans for the future. And I look forward to seeing everyone and hearing everyone. I wish everyone an amazing weekend and happy International Women's Day. Thank you, Chisom, for reminding us about it with all the cross and all the things, bias and all that. Well, we are winners and we actually do a lot. So it's good for us to celebrate ourselves. So thank you so much, everyone. Have an amazing weekend. I love you all.
I love you too. Thank you so much. Bye.
Thank you. Bye.
Everybody. Bye.
Bye.